Good morning. The details of the case that we're hearing today are available on the website of the Judicial Committee of the Privy Council, and I propose to turn immediately to Mr. Parker, Queen's Counsel, who will make his submissions on behalf of the appellants first. Thank you, Mr. Parker.
Thank you. I appear for the appellants with Ian Mann and Paula Kay, and the respondents appear by Mr. Paul Chasey QC, Mr. Nigel Meeson QC, and Mr. Richard Evans. I'd like to begin, if I may, by making introductory remarks by way of overview, and before I then work through my written case, hopefully expeditiously, to conclude within the 2 hours I've been allotted. You will appreciate that before the Court of Appeal there were two issues. The first being whether the trial judge was right to find that there had been unfairly prejudicial conduct. The second issue being whether or not, having found that there was unfairly prejudicial conduct, the trial judge was right to order that the second respondent purchase the appellant's shares. The Court of Appeal agreed with the judge on the first issue, but overturned the buyout order that the trial judge had made. The Court of Appeal's decision was that there had indeed been egregious unfairly prejudicial conduct, and that decision is not being appealed. The Court of Appeal held that the appellants were entitled to the financial information that they had asked for, and therefore there was agreement with the trial judge that some relief was needed. And there's also agreement that in deciding on what the relief should be, it was necessary to take account of all the circumstances as they appeared at trial, not simply what had been relied on by the claimants for the finding of unfair prejudice. And obviously this appeal is therefore concerned with whether the Court of Appeal were entitled to review the decision on relief of the trial judge, and if they were, whether they then went on to exercise the discretion afresh correctly. Now, if we may look at the Court of Appeal's judgment dealing with the question of relief, it begins at paragraph 83, and we find that on page 191. And if I might jog through the relevant paragraphs, paragraph 83 is confirmation of what I said, that there's agreement that the court will take into account all the circumstances of the case. 84 is reference to authority. Paragraph 85, there's a repetition of the finding of unfair prejudice on the part of the second respondent. Paragraph 86 begins with the reference to the appellant's conduct, in particular the fact that delay by the petitioner is relevant in the context both of whether the conduct is unfairly prejudicial and also to remedy. And in paragraph 87, one finds the criticism of the appellants for not bringing proceedings to obtain the financial information earlier than they actually did, and a statement that the judge failed to treat this as a material factor. You'll see that at the bottom of the page. And then over the page at the top of 194, we see that the Court of Appeal state he failed to do so and rather seemed to have improperly minimized their contribution to the state of affairs. Paragraph 88 is reference to the appellant's misconduct before May 2006. said that the judge should have placed more weight on it and on also on the failure to ask for the financial statements sooner. Paragraph 89. It said, I'm not persuaded that the justice of the case warranted the learned judge making a buyout order. And obviously we say that's not the right test. It wasn't for me to persuade the Court of Appeal that it was the right order. And goes on to say, I do not share the view of the judge. And there's, we see at 89, there's also a discussion of the Court of Appeal, English Court of Appeal case of Grace and Bagioli. And it said in that case, the English Court of Appeal had good reason to believe that the minority shareholders' future interest in the company would have been prejudiced had the buyout remedy not been ordered. And then at 90, they say, this is page 195, juxtaposing that with the conduct of Lawrence. Now, pausing there, what the conduct of Lawrence is that they're referring to is not clear, obviously, from the opening sentence, and hopefully you will appreciate it from the written cases, that there was misconduct on the part of the second respondent in having a loan of 18 million Hong Kong dollars, which had not been repaid, in having had the subsidiaries pay his legal fees of the Hong Kong litigation, and also in the way in which he had subsequently acquired the shares of other siblings, using their alleged indebtedness to the company as a discount from the purchase price that he had to pay. And then separate from that is the conduct which the Court of Appeal found to be the unfairly prejudicial conduct, which is the refusal in 2013-2014 to provide the financial statements and the revoking of Article 120. But if one reads on, one sees at the bottom of the page that the conduct of the second respondent that they are referring to at 90 is the failure to provide the financial statement. It says at the bottom, in my view, therefore, the learned judge was wrong to have concluded that the conduct of the appellants was not relevant to determining whether Lawrence's conduct was justifiable and proportionate. Now, the only conduct of the second respondent that had been argued was justifiable and proportionate was the refusal to provide the financial statement. There'd been no attempt to say that his financial misconduct was justifiable and proportionate. His financial misconduct preceded anything that the appellants had done. So we know that this is referring to the unfairly prejudicial conduct in not providing the financial statements. Now we say that is a very confused statement, because when one's considering the remedy, the issue isn't whether the second respondent's conduct was justifiable and proportionate. The court has already held that it wasn't justified and it wasn't proportionate. And if we could go back to page 187 and look at page 74, paragraph 74, we see the Court of Appeal's finding that withholding of financial statements wasn't justified and wasn't proportionate. And we say it's further confused because the point that the English Court of Appeal made in Grace and Baggioli is if the conduct of the petitioner didn't justify the conduct of the respondent, then it's difficult to see why the conduct of the petitioner should come back in at the remedy stage for the purposes of then depriving the petitioner of a buyout order that the petitioner would otherwise be entitled to. But in many ways, the more fundamental point is on the question of remedy. The Court of Appeal took account of the appellant's alleged misconduct. And I say alleged misconduct, not for the purpose of suggesting that what the appellants did pre-May 2006 wasn't misconduct, but for the purpose of highlighting that the fact that they did not ask for financial information until November 2013 could not properly be characterized as misconduct, particularly in light of the trial judge's findings as the reason why they hadn't asked. But the Court of Appeal take account of what the appellants did by way of misconduct, but Lawrence's own misconduct should also have been taken into account by the Court of Appeal. The misconduct other than the unfairly prejudicial conduct which they found, but the Court of Appeal never did. Then, paragraph 91 is discussion of authorities. Paragraph 92 on page 196. We see it says, insofar as the learned judge had exercised his discretion improperly, he committed an error of principle in so doing. So they're saying the alleged failure of the trial judge to take account of the appellant's conduct was an error of principle, so that they could exercise the discretion afresh. And then, simply by asserting that they, the Court of Appeal, were taking into account all the circumstances, without discussing what the relevant circumstances were, they then overturned the judge's buyout order. But we say consideration of paragraph 90 that we just looked at shows that the only conduct of Lawrence that they were taking into account was its failure to provide the financial statements. So we say it's a glaring defect that they concentrate on the appellant's misconduct, but they totally ignore the second respondent's misconduct, other than the unfairly prejudicial conduct which they have found in not providing the financial statements. So the historic conduct of the appellants, the Court of Appeal finds relevant. The historic misconduct of the second respondent, they wholly ignore. And that includes the episode of the acquisition of the shares from the siblings at a cheap price. And if I might just show you what that is a reference to, that one's clearer on that. Page 107. At the judgment of the trial judge, paragraph 85. This deals with the essence of the misconduct in the acquisition of the shares from his siblings at a time when they had not been given any financial information as to the value of the shares either. He also deducted from the price that he was paying for the shares the loans that they, his siblings, he said, owed to the company. There's no mention of any of that in the judgment of the Court of Appeal. But if that defect...
Could I just ask a question about that? Was it proved that the company was never repaid for that discount?
It was, yes, it was not suggested that he had made good.
Well, was it, did the petitioners, sorry, the claimants show that he didn't actually account for the benefit of the discount?
Well, the claimants alleged that was wrongdoing. Now, in the position of the claimants was that obviously it would have been at that point for the second respondent positively to assert a repayment if such repayment had occurred.
But you're not saying that the part of the allegations of unfair prejudice were the failure to account for that discount?
It's more the fact of it having happened.
Yes, but it wasn't one of the grounds for unfair prejudice. It's certainly not one that the judge found. It's not unfair prejudice just to have a deal with the other shareholders, which is not beneficial to them. The only element of unfairly prejudicial conduct is in failing to secure the company was duly recompensed.
Well, there are two elements. The first of all is the director having the pecuniary benefit of paying less by virtue of deducting from it the loans that were payable to the company. Now, that wrongdoing could be subsequently remedied by a repayment. But there's no suggestion that ever had been a repayment. This was relied upon as unfairly prejudicial conduct. But the judge was very much taken with the fact that the negotiations, the acquisition of shares from Sibling, were always in the context of the second respondent not having provided any financial information. But the judge did find, it's not so much a finding on this, because the misconduct on the part of the second respondent was asserted by the second respondent in his witness statement. One of the things that perhaps I'll come on to, because I've seen my learned friend criticise the trial judge for a lack of clarity in his findings of fact with respect to the second respondent's misconduct. And that criticism, in my submission, is utterly misplaced, because this wasn't a case of the judge having to make a finding on a dispute as to the factual position. The allegations of the second respondent's misconduct simply repeated back to the second respondent what he had said in his witness statements or in other documents. And we'll see in due course that when the judge sets out the second respondent's position on his misconduct, there's no denial. The assertions were, it's historic, or it's not conduct of the company's affairs. Now, as I say, there's no mention of the second respondent's financial misconduct, nor was there any mention by the Court of Appeal, which is even bigger point in my submission, of the actual reasons that the trial judge, his principal reasons, the trial judge put forward in support of his decision that it was, quote, abundantly clear that a buyout order was appropriate. And if we could turn to the trial judge's judgment at pages 129 to 130, I wonder if you'd be so kind as to read through paragraphs 202 through to 209 inclusive. So you see there that the trial judge is very concerned by the attitude displayed by the second respondent to the minority generally, and the principal reasons in my submission appear from paragraph 207. The first principal reason, was the second respondent's, quote, completely unjustifiable failure to provide the financial statements over many years, even when asked. And the second reason is long and strongly held misguided perspective that the appellants were not entitled to the economic benefits of the shares as they were given the shares and as they did not work to build the company. And also, those are the two principal reasons appearing in 207, but the judge also had regard to the second respondent's financial misconduct with respect to the affairs of the company dating from before May 2006 and to the way in which it purchased the shares of the sibling. Now, none of the facts on which the judge based his conclusion are the subject of the appeal. And obviously, the first reason that was given by the trial judge was endorsed by the Court of Appeal. That's the failure to provide the financial statements. The second reason, his attitude that the appellants were not entitled to any economic benefit, that was based on what the second respondent said and what his counsel had said on his behalf. And we see that referred to in the judgment on page 131 at paragraph 217. Reference to his litany of criticism, constant reference to the fact that they had been gifted the shares, they hadn't done any work, and as far as he's concerned, all they wanted was money. The second reason was, of course, connected to the first reason, because the second respondent had put forward his views of the appellants as being simply interested in money as its justification for withholding the financial statements. None of this was pleaded, but it was relied on at trial. And in any case, it obviously doesn't need to be pleaded by the second defendant for it to be, second respondent, for it to be a matter that the court could have regard to in the exercise of its discretion on the question of relief. And obviously the Court of Appeal didn't say any of this needed to be pleaded by the second respondent for it to be able to rely on it, misguidedly as it turned out, nor did the Court of Appeal say that the second respondent did not have the attitude towards the minority that the trial judge said he had. Now, the Court of Appeal did not say that the judge erred in principle by having regard to the second reason. No reason why the Court of Appeal should have said. But they didn't say he was wrong to have regard to the second reason. Nor does the second respondent now say that the Court of Appeal should have said that the trial judge erred in principle by relying on the second reason. What is perhaps the most remarkable thing of the judgment is that the Court of Appeal make no mention anywhere of the judge's second reason. It's totally ignored. And we say that of itself renders the Court of Appeal's decision unsustainable. Now, if we could just go back to the Court of Appeal's consideration of Grace and Bajaj, because we say that shows how extraordinary their decision was. Go back to page 194, please. And in paragraph 89, dealing with Grace and Badger, we see at the bottom of page 194, it says, in that case, the English Court of Appeal had good reason to believe that the minority shareholders' future interest in the company would have been prejudiced had the buyout remedy not been ordered. This is exactly what the trial judge was saying by the second reason. And over the page, at the end of paragraph 89, in ordering a buyout, the court took into account the totality of the circumstances, including the likelihood of future disputes between the appellant and the other three shareholders. The court was of the view that the buyout order was most appropriate to ensure that the appellant's rights are respected in the future. And I repeat, that's what the judge was saying, referring to by his second reason. There's no awareness that by the Court of Appeal, that the trial judge come to the same conclusion as the Court of Appeal in Grace and Badger and was making a buyout order by reference to his concern as to the fact that the second respondent wished to control the company as if it was solely owned. And it would be appreciated that the second respondent now is not seeking to defend the decision of the Court of Appeal on any grounds other than those which appear in the judgment itself. And the second respondent spelt that out at paragraph 2 of its written case, as required by Rule 25 of the Judicial Committee's rules. So we say the judgment is unsustainable because it omits any consideration of the trial judge's second principal reason, and the second respondent offers no additional grounds on which, as it said, the Court of Appeal's decision could be correct. And as I say, the Court of Appeal didn't identify any factual findings on which the trial judge based his second reason as being plainly wrong. There's no challenge to any finding of fact as being plainly wrong. And you are asked to keep that firmly in mind when listening to my learned friend's submissions. And obviously, it's not therefore necessary to remind this court of the advantages that the trial judge has when considering issues of fact, nor of how difficult it would be to overturn any finding of fact as being plainly wrong. And this is a point I make in paragraph 5 of my written submissions, which I will say, and now propose to follow. So if you could perhaps read along whilst I'm addressing you. So paragraph 5 makes the point that we're dealing with facts as found by the trial judge. And they then go on to set out what the relevant facts were as found by the trial judge. And hopefully you've been able to read through this, but you will have appreciated that of significance to the relationships of the parties were the events giving rise to and the duration of the Hong Kong litigation, in that the siblings, all with the exception of the second respondent, were proceeding on the basis that they were equal shareholders, because that is what the Chinese memorandum, effectively the will of their father, had said when it was read to them in September 1992, on the basis that they would each receive 10,000 shares upon his death. And when the father died, they received their 10,000, each received their 10,000 shares, and matters proceeded for a year on that basis. When the second respondent, when his control was challenged, announced that he had in fact got additional shares, which would give him majority control. The siblings were, as the judge says, understandably, this is paragraph 12, understandably and not surprisingly, sorry, forgive that, the siblings were understandably doubtful as to the authenticity of these additional shares, and they commenced litigation, challenging the genuineness of their father's signature, and they did so in 1999. Now, they were successful at first instance, and that enabled them to take control of the company. They were also successful, the siblings, in the Hong Kong Court of Appeal. And it was during the period of control that they sought to achieve parity with the second respondent by taking money out of the company to the amount that the second respondent had, and in purporting to pass a resolution to give themselves the same number of shares. That money was repaid, and obviously those shares were of no validity. Ultimately, they lost in the Hong Kong Court of Final Appeal, and the second respondent resumed control of the company. Now, as we see in paragraph 9 of my written case, the trial judge specifically found that the actions that were taken by the appellants whilst in control of the company were not the reason for the second respondent subsequently withholding the financial statements from the appellants. Paragraph 10 of my written case, no dividends were ever paid out. That wasn't in dispute. But once Lawrence was in control, from May 2006 onwards, he didn't pay any dividends. And the judge makes the found, as we see again, paragraph 10, despite having had the benefit of high quality legal advice, the attitude of the second respondent was and remained that members who did not work in the business were not entitled to dividends. That's the second reason, as I've been calling it. Paragraph 11 sets out the financial misconduct of the second respondent. And then there's a reference to his flexible attitude to various payments. Because before he revealed he had the 10,000 extra shares, payments were made from the company to the siblings, which in the Hong Kong litigation were described as dividends, but for the purpose of this litigation, the second respondent said were loans. There's then reference to the purchase of the shares. And then paragraph 12 of my written case, I quote from the trial judge, understandably and not surprisingly after the outcome of the years of bitter litigation in Hong Kong, and given their understanding of the nature of the second respondent, who did not provide the financial statements when he was asked to in 2014, the appellants did not seek any information about the company or its business or affairs from the company or from the second respondent until the second respondent asked to buy their shares. And this is perhaps important. In any event, in light of the bitter history, the appellants cannot be faulted for not pressing for financial statements. So the evidence from the appellants as to why they hadn't asked for financial statements was to say, well, what's the point? We knew our brother. There's no point asking. Which is what the judge accepted, pointing to the fact, as the evidence of the second appellant did, that if you look to see what happened when they did ask for financial statements, it simply confirmed the view they had taken previously. There was no point asking. Paragraph 13 of my written case, the second respondent's conduct of the company reflected the fact that he viewed the company as his own. He, quote, has very strong and long-held views that the appellant should be entitled to nothing. That attitude is manifest in the second respondent's witness statement from his counsel's cross-examination. Again, this reference we've seen, the litany of criticism came through loud and clear. Then paragraph 14, the financial statements that were supposed to be provided without a request having to be made were not provided in the years 2006-2013. There's then reference to November 2013. The second respondent contacted the second appellant to explore the possibility of acquiring the shares, and by offering to pay the same amount that he had paid for the shares of the three siblings whose shares had been acquired years before, which is what prompted the second appellant then to ask for financial statements. Reference to the fact that the second respondent couldn't see anything wrong with the way that he conducted himself. Paragraph 15, finding that the second respondent had no proper explanation for the court at the time for not providing the financial statement from 2006 onwards, or for when he was asked for them. Conclusion, which is the one shared by the Court of Appeal, that the refusal was for his personal improper benefit. Then paragraph 16, there's reference to the correspondence seeking the financial statements that ultimately led to the litigation. As we see, paragraph 17, there's reference to the fact that the appellants reasonably, legitimately and justifiably had a lack of trust or confidence in his future management of the company and in his future conduct as a sole director. Now, it's fair to say that subjectively, that was a view they'd long had. But the court's concluding that there was good reason for them holding that attitude. Paragraph 18, the same respondent no longer has the ability to deal with the minority appropriately and has not had that ability for some time. The situation is untenable. Further disputes were inevitable, and the appellants in the court lacked the resources to ensure that the second respondent acted appropriately. And we say, paragraph 19, in light of this fact, particularly with regard to the highlighted matters, it may be thought it would have been remarkable if the judge had not thought a clean break was needed in order to buy it. And that his animosity towards the appellants wasn't a generalized animosity without legal or economic consequences. It meant that the minority shareholders would never receive a dividend, whatever the profitability of the company through its subsidiaries. This is something the Court of Appeal completely overlooked. Then I addressed the Court of Appeal's view that the judge had erred as a matter of principle. Now, paragraph 21 makes the point that the judge was fully cognizant of the appellant's misconduct. Their financial misconduct in the period 2004 to 2006 and is set out fully, the allegations of misconduct were made, set out fully in footnote 34. And the reference, footnote 34 is on page 116, but I don't think we need to take time to go to it at this point. The paragraph 21 makes the point that simply for a judge to say that the misconduct isn't relevant isn't a statement that misconduct, as a matter of principle, is not relevant to the question of relief. It reflects the judge's consideration of the circumstances of the case as a whole and his conclusion that the appellant's misconduct is not a matter to which he attaches significance in his consideration of the relief that he should grant. And indeed, he had concluded that the misconduct wasn't the reason or justification for the unfairly prejudicial conduct, which, as I say, it's a conclusion that the Court of Appeal endorsed. And we say that the confusion of the Court of Appeal on this whole point of the appellant's misconduct is apparent when one considers paragraphs 87, 88 and 90 of the Court of Appeal judgment. Now, if I may go back to those paragraphs, we looked at them when we were conducting an overview of the judgment generally. But if we could go back to page 194, we begin with paragraph 88. And we're reading this in conjunction with paragraph 23 of my written case, which records that in paragraph 88, we see the statement that's accepted by both sides that the appellants, while they had effective control of the company pre-2006, gave themselves shares and took money out of the company. Even though Mr. Parker stated that this was in response to the second respondent's own misconduct, be that as it may, this is a factor that the learned judge should have taken into account in his determination of the appropriate remedy. Now, to make the point, it isn't said why this is relevant to whether a buyout should be ordered. There was an issue as to whether the appellant's misconduct justified the unfairly prejudicial conduct, or justified the conduct of the second respondent, which ultimately was held to be unfairly prejudicial. And it was concluded that it did not. So that begs the question then, why is it said to be relevant to the judge's determination that a buyout is the appropriate remedy? And that statement, emphasizing the misconduct of the appellants, the financial misconduct of the appellants, we say is extraordinary because at the same time it ignores the financial misconduct of the second respondent. And we say that's turning things on their head, because the second respondent took money, unlike the appellant, he didn't return it, and unlike the appellant, he remained in a position to continue to extract money. But, moreover, as we say in paragraph 24 of the written case, the premise of the statement of the Court of Appeal is wrong because the judge expressly did have regard to the appellant's misconduct when considering what relief to grant. He addressed this misconduct in paragraph 37 of his judgment, and I set out in my paragraph 24 what he said, but we have paragraph 37, page 98, beginning at page 98. Bottom of page 98 there says, while those actions do not reflect well on those involved, they are of little relevance or no relevance to the central issues of this litigation. In particular, they did not justify the second defendant's actions in relation to the financial statements, nor were they the reason for his actions regarding the financial statement. And those actions do not inform this court on the relief that is appropriate. So we can see that the trial judge was fully aware of the fact that the misconduct of the appellants had to be considered, both on the question as to whether or not the conduct was unfairly prejudicial, but also on the issue as to what relief should be granted. And we say that the judge had thought that the actions of the appellants were, as a matter of principle, irrelevant. He would not have needed to explain why he thought those actions were of little or no relevance on the question of relief. The judge also considered these matters at page 130, paragraph 135, which is page 116. He refers to the appellant's misconduct and says, these matters do little to substantiate the second defendant's asserted concern about disruptive or difficult behaviour as a reason not to provide the financial statements in 2014 or later. Further, this court does not consider these matters of any relevance in the exercise of its discretion regarding the appropriate relief remedy. Again, consciousness of the fact that the conduct could, as a matter of principle, be relevant on the issue of remedy, but concluding that in the circumstances it shouldn't affect the relief that he's minded to grant. In paragraph 6 of my written case, I make the point the Court of Appeal did not bother to explain why the appellant's actions pre-2006 were sufficient to deprive the appellants of a buyout order in 2016. The Court of Appeal proceeded as if, as a matter of principle, any previous misconduct by petitioners, however historic, deprived them of a buyout remedy. And obviously, they were wrong to do so. Now, just to pause there, I appreciate that if the Court of Appeal had been right to say, which they weren't, that the trial judge had committed an error of principle by failing to have regard to factors that were clearly relevant to the issue of relief, that at that point, the Court of Appeal exercised its discretion afresh. But paragraph 26 in my written case, I say is correct, because when the Court of Appeal went on to discuss the appropriate relief on the basis of having found an error of principle, there's no reference at all to the relevance of the appellant's conduct. So the appellant's misconduct is used by the Court of Appeal simply to deprive the petitioner of his buyout order, but with no explanation as to why it should deprive the petitioner of his buyout order, a fortiori, given they have found it didn't justify the conduct of the petition. So the only inference is they view it as an absolute. You have misconduct by the petitioner, ergo, the petitioner can't have a buyout order. So that's how they deal, that's how the Court of Appeal deals with the financial misconduct, I'm calling it, the pre-May 2006 misconduct. And then we look to see how they deal with the fact that the appellants didn't ask for financial statement until November 2013, didn't begin proceedings until 2014. And again, staying at paragraph 88, paragraph 88 of the Court of Appeal's judgment, as I set out in paragraph 27 of my written case. The Justice of Appeal Blenheim says the judge ought to have placed more weight on the fact that for several years the appellants did not make any requests of the second respondent for financial information until 2014, when the matter of the sale of the second appellant shares was being discussed. But as I said, the judge had addressed that and had accepted there was a good explanation for why they hadn't asked. So we say paragraph 28. It's wholly unclear as to why this was viewed as a factor against the appellants, given that, first of all, the Court of Appeal had found that the relief was predicated on the failure in 2013 to give the financial statements. And secondly, they went on to find that on the question of unfair prejudice, the second respondent had been at fault in the years 2006 through to 2013, 2014 in not providing the financial statement. And I set out that finding in paragraph 28 with a footnote reference. So the Court of Appeal said, well, we don't think it's appropriate for that to be sufficient unfairly prejudicial conduct for the purposes of founding a petition. But obviously, when it's asked for, the financial statements are asked for and they're not provided, then that's not historic, that's unfairly prejudicial conduct. But they specifically find, in the context of looking at all the circumstances of the case, that the second respondent was at fault for not having provided the financial statements earlier, given that there was no obligation on the appellants to have asked for them. And we point out in paragraph 29.
Could I just ask a question? Do you say the Court of Appeal were wrong to disregard the failure to provide financial statements before 2013? Because they say it wasn't unfairly prejudicial.
I do not.
Right.
We have the finding of unfairly prejudicial conduct has been upheld by the Court of Appeal. We're perfectly content with that. The Court of Appeal did criticise the trial judge for having viewed the failure in the years previous to that as also being part of unfairly prejudicial conduct. But the important point we rely on for the purpose of relief is that the Court of Appeal accepted that the second respondent was at fault in the years 2006 through to 2013, 2014 in not having provided the financial statements, given that under the articles, the shareholders had the right to the annual financial statements without having to request.
Yeah, they had that right before 2013.
Yes, they've always had that right. They were entitled to the statements without request. Now, they didn't request them, as it happens, because as the judge found, given the bitter litigation in Hong Kong, the appellant's view was their relationship with their brother was such that if they had asked, they would not have been provided with them, a view that was shown to be justified in 2013, 2014, when they did ask for them, and the response was they didn't get them, and their right to them was removed from the article.
Mm-hmm.
Now, paragraph 929, we just highlight the fact that here the Court of Appeal is talking about a failure on the part of the trial judge to give sufficient weight to the fact that the appellants had not asked for the statements. We say, well, first of all, that's inconsistent with saying that he didn't have regard to this at all. It's saying he did give weight to it. But they go on and say he didn't give sufficient weight to it. But we say, well, that's not a matter, that's not an error of principle. The weight to be given to factors is a matter for the trial judge in the exercise of his discretion. And then in paragraph 30 of the written case, we say, well, the Court of Appeal is clearly wrong to have referred to the appellant's forbearance in asking for financial statements as being blameworthy or material misconduct. We say that that's simply illogical. There's nothing blameworthy or in the nature of misconduct by not bringing proceedings to ask for financial statements that you're entitled to. And there's no explanation in the Court of Appeal's judgment as to why the view was taken that it was reprehensible conduct. And we see reference to this being misconduct. If we go to the page, paragraph 31 of my written submissions, we see reference to this being misconduct in paragraph 87 of the Court of Appeal's judgment. It's just a complete mischaracterization of the conduct of the appellants. And then paragraph 32, the point I've already made, is that the Court of Appeal not only shouldn't be referring to it as misconduct, but is totally ignoring that the judge has found that there was good reason for their not having asked for the financial statements. And you will see in paragraph 32 reference to paragraphs 90 to 92 of the trial judge's judgment, making it clear his finding that this is a perfectly understandable reaction on the part of the appellant to what has happened during the course of the Hong Kong litigation. Buttressed, I repeat myself, buttressed by the fact that when they did ask for the financial statements, they never got them. Again, something that the trial judge referred to in paragraph 92, and which the Court of Appeal completely overlooked. Then, paragraph 33 of my written case, focusing on paragraph 90 of the Court of Appeal's judgment. And the Court of Appeal's reference to the fact that it is settled law that the petitioner's conduct may affect the relief that the court thinks fit to grant. And then going on to say, quote, in my view, therefore, the learned judge was wrong to have concluded that the conduct of the appellants was not relevant in determining whether the second respondent's conduct was justifiable and proportionate. And we say, well, that's just wrong, because the trial judge clearly had proceeded on the basis that he did not need to consider whether the conduct of the that he did need to consider whether the conduct of the appellant should cause him not to grant relief that he otherwise would have been minded to grant. But he concluded that the petitioner's misconduct in this case was of, quote, little or no relevance, and he explained why he thought that. And we say, therefore, in light of what the trial judge actually said, and this is paragraph 35 of my written submissions, that the statement that the judge was wrong to conclude that the conduct of the appellants was not relevant in determining whether the second respondent's conduct was justifiable and proportionate is remarkable, given that the trial judge clearly did consider whether his conduct was justifiable and proportionate in light of the appellant's conduct, and expressly concluded that it was not. He decided that the appellant's conduct was little or no relevance to the central issues of the litigation precisely because they didn't justify the second respondent's actions in relation to the financial statements. And I set out reference to 214. And as I say, that is something that the Court of Appeal itself agreed with. There is extensive consideration by the trial judge of the second respondent's contention that his actions and attitude were justified by the appellant's conduct. In paragraph 36, I set out the copious reference, and I set out a summary of the judge's position, that notably the second respondent's asserted concerns, even if justified, which this court has concluded was not the case, were not about disruptive and difficult behaviour towards the company, but about such behaviour towards himself as sole director. There's no proper basis to justify the second respondent deciding that the company should operate under cover of darkness and as if the company were his alone. So I make the point in paragraph 37, using the words of Lord Justice Lloyd, but it's a matter of common sense in my submission, that the conduct was neither sufficiently serious nor sufficiently closely related to the unfairly prejudicial conduct to make it appropriate for the court to exercise discretion and refuse to grant him a remedy under remedy which it would otherwise have granted. So paragraph 38, we say simply wrong of the Court of Appeal to proceed as if the challenger had thought the appellant's misconduct was not relevant to the question of relief. And we say 39, that the Court of Appeal then itself applied the principle that conduct is a relevant consideration illogically by assuming that where conduct of the petitioner forced to be considered, it must, rather than may, adversely affect the relief which is to be accorded. And we, paragraph 40, make the point that having thus erroneously held that the judge had not considered whether the conduct of the appellants justified the second respondent's conduct, the Court of Appeal then itself did not actually consider whether it did. When considering whether any conduct of the appellants was relevant to the relief granted, the Court of Appeal should have asked itself why, if the appellant's conduct did not preclude a finding of serious unfair prejudice, it was nonetheless conduct depriving them of a buyout remedy to which they would otherwise have been entitled. And the correct Court of Appeal is inexplicable, simply overturned the buyout order as if the appellant's conduct had justified the second respondent's conduct, but without itself holding that it did and expressly finding that it had not. And that was clear from paragraph 74 of the Court of Appeal's judgment itself. And what the Court of Appeal completely overlooked was that the relevance of the appellant's conduct was actually in the second respondent's stated perception of it as giving rise to a justifiable grievance, entitling him to disregard their right. We say, paragraph 42, the criticism there expressed was misplaced because the judge did have regard to it. He had very much in mind the appellants were not without blame for the breakdown in relations. Specifically said as much in 213 and 214 of his judgment. We say, therefore, the Court of Appeal simply had no basis for concluding that the judge had erred. So it was not entitled to revisit the discretion that the trial judge had exercised. Now, if my submissions on that were to be rejected, we also take issue with the way the Court of Appeal then went on to exercise the discretion fresh. Because the simple point is that the Court of Appeal clearly did not then have regard to all the circumstances of the case. I'm sorry, Boris.
If I may, just before you move on to that next section, I'd just like to be absolutely clear about the submission you're making about the judge taking into account or not taking into account the conduct prior to 2006. He used the phrase that it's of little or no relevance. Now, what I understand you to be saying is that the judge did take that conduct into account, but in the circumstance of all the circumstances of the case, when it came to the relief, he was giving it very little weight because in terms of remedy, it should have had almost no weight. Are you therefore saying that it might have been better had he expressed himself slightly differently? Because the phrase no relevance might be regarded as almost saying, as a matter of principle, it's got no relevance, rather than it can be taken into account. I am thinking about it, but actually on the circumstances, I'm giving it effectively virtually no weight.
I am saying that I accept there's an ambiguity, but in my submission, when one looks at in the context in which the words little or no relevance are used, it is clear that he was not addressing this as a matter of principle. He was addressing this as a matter of weight.
No, it's a slightly unfortunate phraseology, and are you perhaps suggesting that nitpicking on this sort of phraseology of a trial court judge might be regarded as somewhat inappropriate for a court of appeal?
Yes. Thank you. Yes, I am. I think it is clear from the context that he was not, as a matter of principle, the misconduct of the appellants is irrelevant, because the misconduct of petitioners is irrelevant to the question of relief. It is absolutely clear that is not what he's saying. And that is clear from the whole debate he has about the alleged misconduct, for the purposes of not only, as he makes clear, concluding that it is not a justification for the unfairly prejudicial conduct, but specifically saying that he has it in mind on the question of relief. It concludes that in the circumstances, principally because it was not the reason why the second respondent behaved as he did, he accords it little or no relevance. The word little of itself, in my submission, precludes anybody thinking he was saying as a matter of principle it was irrelevant.
There is an authority to the effect that the Court of Appeal should not subject the trial judge's judgment to a narrow textual analysis. Those are the words used. I can't remember what the authority is. I think it's Lord Hoffman, and it's not the Biogen authority, I don't think, in order to give themselves the opportunity to exercise the discretion. But it might be helpful to identify that authority.
Well, I'm hoping my juniors are diving into their research tools.
I think Mr. Chase is going to give the answer.
I think it's the case of Piglowska.
Oh, it is. Yes, thank you. Thanks.
Could we just try and pursue the point a little bit more, just to hammer it home? And I'm not expressing any view about this, I just want to test it. If the judge had said to himself, well, look, the claimants had been perfectly prepared to live with this situation for 7 years, they were perfectly prepared to tolerate that behaviours might be going on with which they would consider not wholly in their interests. Do you think that that would have been something he should have had regard to in saying, well, they should not be prepared to put up with this conduct any longer? I just want to see how you react to the question, well, if he had taken it into account, I'm sorry, if he did treat it as a matter of weight only, how did he reason it out?
Well, in my submission, he took the same approach that the Court of Appeal took in Grace and Bagliola, which is to say that if the misconduct is unconnected to the unfairly prejudicial conduct on the part of the respondent, it's difficult to see how it could lead to denial of the relief that the court was otherwise minded to grant.
Well, my point was that he would go through his mind that there had been 7 years when they were perfectly happy to live with the possibility of all sorts of things happening in which they were taking no interest, because they weren't asking for financial information to which they were obviously entitled. Even if Article 120 hadn't been there, they'd have had some entitlement, but Article 120 did crystallize it. There was no doubt the article was there all the time. So I'm trying to put the case against you just to try and understand how you react to it. He is saying to himself, well, they were perfectly happy to live with this situation. And the respondent thought, the second respondent thought that was probably so. What weight was he giving to their objection now, when there was a prospect of selling their shares, to getting the information according to the letter of the article? Didn't he have to see it in context?
Well, but just he'd addressed the particular factual circumstances. He concluded that it wasn't a case of them being perfectly happy. It was a case of the fact that whilst they would have liked to take an interest, they thought, I used the expression battle weary, that the judge concluded that after years of because of the bitter litigation, and because of their understanding of their brother, at that time, their view was there was little point in asking for financial information that he wouldn't be minded to grant. And obviously, given that litigation that they'd just gone through, they weren't minded, and I am extrapolating at this point, they weren't minded to commence another round of litigation about the financial information. And indeed, at that time in 2006, they had historic information because the receiver had been appointed during the Hong Kong litigation, and there'd been some investigation into the financial affairs of the company, which as a result of the receiver saying, look, he's had 18 million Hong Kong dollars by way of a loan, and he's utilised subsidiary to pay legal expenses of the litigation. Now, going forward, obviously that information becomes more and more historic, but they retain the view that there's no point asking for financial information because it's going to lead to litigation. When you get to 2013, there's immediate relevance to financial information because the second respondent approaches the second appellant, asking if he can buy shares and offering a price which prima facie is obviously not a fair price because it's the same price that he paid to the siblings previously with the deduction of the alleged shareholders' loan. So he offers a price which prima facie is clearly unfair. And at that point, understandably, there's a request for financial information, which at that point, the second appellant and the appellants generally are not prepared to back down.
Yes, just two things. Sorry. Pardon me, I thought you finished.
It's 10 years since the previous bit of litigation. They're obviously now prepared to have some more.
Well, just to pursue that point, once they had said to themselves, we don't want to go into this anymore in the light of our Hong Kong litigation experience, they were taking a strategic decision at that point. They had to take it fully aware of what the consequences are.
Yes, and this is all part and parcel of the Court of Appeal saying that's too historic to have founded a independently standing ground of complaint for the purposes of alleging unfair prejudice. That's gone. You can't go back and say, well, that's unfair prejudice by our shares, but it's still pertinent as demonstrating the attitude of the second respondent, in that he didn't provide the information, even though under the articles he was under an obligation to do so, at a time when no dividends are being paid. And after 10 years, you have a situation where such financial information as the appellants had was wholly out of date because it was 2006, and they had not received a dividend in the meantime. And the connection between the financial statements and the non-payment of dividend is something that's referred to in the statement of claim, and it's obviously self-evident in terms of an inability to make a complaint about non-payment of the dividend without the financial information that would show that a director discharging his fiduciary duty to consider the payment of dividends would have paid a dividend. So the point's made in the statement of claim, once the financial information is provided, and it was anticipated it would be in the course of proceedings as disclosable information, at that point, the fact of non-payment of the dividends could itself have become a ground of complaint for unfair prejudice.
But it didn't.
It didn't, because the financial information was not provided.
Well, wait a second. They must have realised that there was a question about dividends. They were receiving nothing from the company. They were living out of Hong Kong, somewhere else. They would have expected an income, but they were perfectly prepared to accept there wasn't one. That's what would be said, wouldn't it? And that they have not gone back over the years when they didn't get financial statements to say all sorts of things happened which caused loss to the company, for which we should be compensated.
Well, they're at that point, the point at which they're not being given the financial statement, that becomes a consideration. But they are then interested. It's, you know, it is true they have been letting sleeping dogs lie, and the trial judge made findings as to why that was, concluding that they could not be criticised for having taken that view.
Well, it wasn't an answer to that. Sorry.
But the second respondent, having poked the sleeping dog because he wanted to acquire the shares cheaply, was then met with a perfectly reasonable request for financial information, which, for reasons that he's never explained, as the judge found, no explanation as to why his response was then to say, you cannot have the financial statements. And obviously at that point, the context of no dividend having been paid for 10 years gives the refusal to provide the financial statement, it gives it added cogency in terms of concern about how this company is being conducted. And it's at that point that one can say, well, and this isn't a paragon of virtue. This is a man with a history of financial misconduct. And again, your ladyship's observations were all relied upon by the respondent, but unsuccessfully, for the purpose of saying that his response was justified and proportionate. And the trial judge and the Court of Appeal said, not so.
Yes, that's a separate issue, of course. I'm not talking about the finding of unfair prejudice. Thank you.
Well, it is a separate issue, but on the question of relief, it comes back to the fact that, again, when one throws in, it's the judge's second reason. If you just have the first reason, the failure to provide the financial statements, free of any context, if you just have that, then one can understand the response that says, well, why isn't it sufficient simply to provide the financial information? One can understand that. But when one's got the second reason of the judge, look, not only has he not paid any dividend, he's made it quite clear there's no intention of paying any dividend. At that point, the failure to provide the financial information does not become freestanding. And the conduct, therefore, of the appellants in not having asked for it previously pales into insignificance against the response of the second response.
But in looking at that second question, then the judge has left out of account the issues about whether they were entitled to complain in respect of the period up to 2013.
Well, he hasn't left it out of account. He's discussed it.
Well, sorry, he's left it out of account at the remedies point because he says it's no relevance, and you've got to assume that he's acting on what he's decided at 37.
So he's acting, I do apologise. He's
on the basis, I'm so sorry, on the basis of what he had decided at 37. So he's saying to himself, I leave out of account the fact that they have been prepared to accept all this up to 2013 and had themselves been guilty of misconduct. I'm just wanting to know how you react to these points, what the answer is.
Well, in my submission, the answer is that which is given by the trial judge. He hasn't left it out of account. He has fully considered it, both in the question of liability and the question of relief. And the way that he's attached to it is to say he thinks it's of little or no relevance. And I do not find, in my submission, I do not find in the Court of Appeal an explanation as to why it is relevant.
Thank you.
Is that a good moment, Mr. Parker? To
Thank
have
you.
5 minutes.
Yes,
We will resume in 5 minutes' time, which on my clock, which probably everybody's got random timings, is 11:56 for resuming.
Thank you very much.
Thank you. Yes, Mr. Parker, I think we're ready to resume. Thank you very much.
Sorry if I kept you rating. I was a little engrossed there. I apologise.
Not at all.
Moving on, as I say, move on now to on this. If it is the case that the trial judge erred in principle, we say that then the Court of Appeal completely disregarded highly pertinent circumstances in exercising its discretion afresh. And as I indicated in the overview, the two particular circumstances are the misconduct of the second respondent itself, which is extraordinary given the focus on the appellant's misconduct, and also the second reason. Paragraph 45 of my written case make reference to paragraph where the judge specifically sets out his two principal reasons. Paragraph 207. The reference in brackets says, although the court will show no appreciation of the fact it is obvious that the two are related, should be for paragraph 58. And I make the point of the Court of Appeal ignoring the judge's second reason. We saw that the Court of Appeal referred to Grace and Bagioli, and that it is worth just looking at that authority, which is at page 2490. The facts of the case were that there was the appellant and three respondents. They set up companies in the United Kingdom, the US, and France, in which they were equal shareholders and directors. With the appellant having responsibility for the French company, which, unlike the UK and the US companies, didn't prosper. A dividend was declared, but on the basis that the French company didn't want, the appellant and his French company didn't want to actually contribute to the dividend, and pressure was put upon him to pay a dividend from the French company, which he refused to do, which led to a situation where ultimately the dividend that the appellant would otherwise have received was withheld from him and paid away the respondents by way of management fees. The petitioner response to the situation was to make inquiries about purchasing a company in the Far East, which would have been in direct competition with the business venture of the appellant and the respondents. And the question of the conduct of the petitioner was therefore pertinent to the question of the relief. And as we see from the head note of paragraph 2, reading halfway through the second head note, the non-payment of the dividend amounted to unfair prejudice against the appellant within the meaning 459, and given the lengths to which the respondents were prepared to go to avoid payment of the dividend, nothing short of a buyout order would ensure that the appellant's rights were respected in the future. 459 was intended to assist a petitioner's shareholder by allowing him to receive the value of the shares in satisfaction of his rights as a shareholder, and neither the fact that he was not an active manager of the business, nor the fact that he did not pay for his share, were good reasons for refusing to make a buyout order. Moreover, his predicament of being a minority shareholder who was locked into the company, the fact that both sides had grievances and there was fault on both sides, and the fact that respondents had already taken steps to minimise future dividends which are bound to lead to further disputes in the future, were all good reasons for exercising rather than denying jurisdiction to order respondents to buy the appellant's shares. And in the judgment, the particular paragraph which I would direct attention to, paragraph 73 on page 2508, is making the point that all the circumstances of the case are looked at The court says at the end of 73, the court is entitled to look at the reality, practicalities of the overall situation, past, present, and future. 74 comes on the judge to consider the whole range of possible remedies. Consideration of the likelihood of similar acts of prejudice in the future. 75. In most cases, the usual order to make will be the one requiring the respondents to buy out the petitioning shareholders at a price to be fixed by the court. This is normally the most appropriate order to deal with intra-company disputes involving small private companies. This is the relief which Mr. Grace says the judge should have granted and which he seeks on this appeal. The reasons for making such an order in most cases are obvious. It will free the petitioner from the company and enable them to extract his share, the value of his business and the assets in return for foregoing any future right to dividend. Company's business will be preserved, etc. And then at 77, if you could be so kind as to read 77, one sees the point that it's difficult to see how conduct of the petitioner is relevant on relief if it's been held that it wasn't relevant to the question of unfairly prejudicial conduct. Or sorry, relief. Paul, you want to? Well, a friend think wants to make a.
Sorry, no.
Yes, go ahead.
I'm sorry. Everything. My screen had frozen and I couldn't hear anything Mr. Parker was saying for a few moments. Then I was just trying to attract attention, but seems to be back on. Thank you.
I think Mr. Parker was simply going through the paragraphs of the authority, but if you need anything further, I'm sure.
That's fine. If that's all he was doing, obviously, that's fine. Thank you very much.
I'm not sure when you lost your screen, but that's what he's been doing for a little while.
Thank you.
And then paragraph 79, if you could be scanned to read that, emphasises the importance of a consideration of a risk of repetition, some form of unfair prejudice. And then paragraphs 82 and 83. So obviously we place particular reliance on the words in the middle of paragraph 83 there. If we have that, it's about it's at the end of the sixth line, it says, taking everything into account, it seems to us obvious from the lens which the respondents were respondents were prepared to go to avoid payment of the 2002 dividends, but nothing short of a buyout order will ensure that Mr. Grace's rights are respected in the future. And we say that, bearing in mind the judge's finding about the attitude of the second respondent towards the minority, which was his second reason, that this case and the findings of the trial judge falls squarely within the rationale of a buyout as per Grace and Bajdir. And yet, no reference or consideration of that aspect of the matter when the trial judge exercises the discretion afresh. Paragraphs 46 through to 51, you will have read. I'm by no means saying don't read them again or don't take them into account, but I don't think I could go through them without repeating myself. But I hope I'm forgiven for repeating myself by drawing attention to paragraph 52, that is relevant for relief that should be awarded that the second respondent had benefited personally from the company at the expense of the minority and had never paid a dividend. The evidence he gave and the way in which he chose to present his case showed he had no intention of ever paying a dividend. At 53, on this point about him having benefited at the expense of the minority, I set out the judge's findings with respect to that, which I have alluded to. And I said this wasn't a case where there was a dispute about whether he had done those things. And we see that from the way in which the case was pleaded in, go to, I've got slightly out of sync here, but the amended statement of claim begins at page 2040. And whilst we have that, if we could look at paragraph 6 on page 2041. Which puts the dispute in context that no financial statements of dividend had been paid since May 2016. And the point I was making previously about the connection between not having a financial statement and not being in a position to make complaint about a breach of fiduciary duty in non-payment of the dividends, in circumstances where it was anticipated that one would receive the financial statements prior to the trial as a disclosable document, that's spelled out in paragraph 14 on page 2045. But if we look at paragraph 12 on the point I was making about this not being a situation where the financial misconduct is in dispute, we see paragraphs A, B, C, D, E, and G, the allegations of financial misconduct. And as the allegations made clear, they are all based on what the second defendant himself said in his witness statement, or in the case of G, a reference to the financial records of the group referred to in a letter from a Mr. Robinson.
Could you give me the electronic page for that?
I do apologise. Paragraph 12 is on 2043.
Thank you.
There's specific references to the paragraphs of the second respondent's witness statement that says about how various changes in how he's treating the monies that have been paid out, and about the fact and the circumstances of the purchase of the shares, and the fact that he has taken 18 million without repayment, and that the financial records of the company, as referred to by Mr. Robinson, the receiver, who was a witness for the second respondent, and they all establish the allegations that are set out in paragraph 12. And as I set out in my written case, the judge sets out the allegations. He sets out the second respondent's response to the allegations. I use the word allegations in inverted commas because there's no dispute about them. The second, when he sets out the response of the second respondent, one can see that the response of the second respondent to these allegations of misconduct is not to say they never happened. It's simply to say that for various reasons, they did not constitute unfairly prejudicial conduct of the company's affairs. So when my learned friend says, oh, it's not clear what the allegations of misconduct that the judge's finding has found were, in my submission, that's just a nonsense, because there wasn't any dispute about the actual facts. The only dispute is to whether or not they constituted unfair prejudice. Now, these allegations, we can see by way of amendment, and permission for these amendments was given 13th of October 2015 at the commencement of the trial. They'd been served previously in September, but these were obviously quite late amendments. But as the trial judge himself said in paragraphs 3 and 4 of his judgment, the origin of these allegations was that the fact this case had commenced on the basis purely of, you didn't give us the financial statements in circumstances where there hadn't been any dividends, and we want the financial statement. But as paragraph 14 made clear, we expect to get the financial statement as a disclosable document and reserve the right to make further allegations of a breach of fiduciary duty when we see what the financial statements show. Now, the response and the defence was to raise all the matters that were the subject of the Hong Kong litigation back in 2004-2006. As the judge said, the claimants were saying, well, if we're going to go back in the way you are insisting in the defence, then it obviously makes sense for the claimant to be able to point to the misconduct of the second respondent. You're pointing to the misconduct of the appellants back in 2004-2006. Well, if we're looking at that, you can see that the Lawrence's misconduct. So that's why this all came in late in the day. But obviously the trial judge deals with the case as it's presented to him in the pleadings, in the form they are at, the purpose of the trial. So in my submission, that there isn't anything in my learned friend's constant reference, the fact that the case started off as a sort of surgical strike to get the financial statements during the course of the proceedings, and then expand it on the basis of the financial information that then appeared. That was stymied because they withheld the document and treated it as something they didn't give disclosure. And when one then looks at the amended reply, page 2050, we can see that the previous position of the claimant, saying, well, we're only concerned with non-provision of financial statement, and everything that went on is irrelevant, went on previously, earlier, historically is irrelevant. That's all struck through. Because the claimant is now saying, well, if we're looking at these historic events, in any case, then let's do so fairly. And we are therefore going to rely on Lawrence's historic misconduct, as is shown by the documents that the court will be considering in any case. And the reason I'm labouring this point is because you will have seen that my learned friend, despite saying he's not relying on any additional grounds for those appearing in the Court of Appeal's judgment, highlights the fact that there were statements in the first appellant's witness statement to the effect that the historical events, as we might call them, were irrelevant, which statements were overtaken by the subsequent amendment. So he originally, in his witness statement, describes the claim as it was at that time as proceeding on the basis of the historic events being irrelevant. The decision is taken, well, if the defence is looking at them, we are going to amend. And at that point, as the reply makes absolutely clear, it's no longer the claimant's position that these events are irrelevant. That and also on the question of the judge's treatment of these allegations, the learned friend highlights the fact that in the judgment, that the judge makes reference to matters factor F, when in his judgment there were no matters factor F. But it's an irrelevant observation because the judge rejected the factor in question as being relevant to his consideration of matters. And I think that the origin of the judge's confusion is that paragraph 12 of the amended statement of claim has a subparagraph F. Again, I apologise for sort of dealing with what might be said to be matters of reply, but in the context of going to the pleading, I sought to provide some context to what the submissions that my learned friend will be making. So we say that it's important to bear in mind this second reason. I set out in the written case, following the treatment of the facts, that following the treatment of the facts of the financial misconduct in paragraph 53, that the judge then goes on to have regard to this, and 55 deal with the non-payment of the dividend, taken together with, as I say, the second reason, second respondent's self-declared attitude to the payment of dividend. Clearly relevant to the question of relief, and the judge saying, you see at the bottom of my page 228, the majority member who wishes to operate the company as if it were his own has only one proper option: to make it his own by consensually acquiring the interests of the minority to do so, and to do so without oppressing or unfairly prejudicing them as the means to do so. And we say that his attitude, as evidenced during the trial, was he wanted to treat this company as if it were wholly his own. In those circumstances, a buyout order was almost inevitable. And the judge sets all that out very fully in the paragraph that I have set out in paragraph 56 of my written case, paragraphs 202, first quotes through to 222, taking the liberty of underlining the passages on which we particularly rely. And I reiterate in paragraph 57, there's no appeal against the judge's conclusions about the second respondent having a legally indefensible attitude towards the appellant, or against his pessimistic view, or the judge's pessimistic view of second respondent's future conduct. Again, we set out the judge's further reference to the attitude of the second respondent, paragraphs 58 and 59. Paragraph 59 sets out at paragraph 122 what the judge had to say, and specifically consistent with the second respondent's views in relation to the shares that his father had to his siblings. The evidence of the second respondent suggested that he considered members who do not work contribute to building the business should not receive dividends. All they have wanted is money without having to put in hard work for it. Second respondent's counsel's cross-examination of the first appellant was that the second respondent feels that all you want from him is money for all the work that he's done. So we say the second reason is important. It was clearly grounded in the evidence. It was the basis of finding of fact, and which couldn't be challenged and wasn't challenged. And its absence from the Court of Appeal's judgment means that the exercise of discretion was wholly flawed. The final complaint addressed in the written case is that we say that the Court of Appeal didn't apply the correct test, insofar as might be said that they simply disagree with the decision of the trial judge. A disagreement with the trial judge isn't sufficient. There's got to be a finding that the judges exercised discretion in a way that no judge could reasonably have done so. And we say that when one sees the way in which the Court of Appeal expresses itself, there's no test applied consistent with asking itself whether the trial judge had exceeded the generous ambit within which a reasonable disagreement is possible. And again, I reiterate, your lordships and ladyships will have read my written case, which I stand by, and then I sought to draw it all together, as one's directed to do in paragraph 63. And for those reasons, I would respectfully urge you to allow our appeal. And thank you for listening.
Thank you very much, Mr. Parker. Impeccable timing. I'll just check that nobody's got any questions for you. No. So we'll move on to Mr. Chasty, please.
Thank you, my lady. Our basic position is clearly stated, which is that the issue of determination is what, against all the circumstances, was the appropriate remedy to be granted. And we say that a remedy which was the compulsory purchase of the shares was excessive, was clearly excessive, and was wrong as a point of principle. And what ought to have been ordered by the trial judge is what was ordered by the Court of Appeal, and what, of course, was originally sought by the petitioners in their original claim, namely the correction to the change to Article 120 and the provision of information. If that had been ordered, the petitioners would have been put back to the same position that they were in at the end of 2013 or early 2014. I'm going to go through some of the important characteristics of this case in a moment. Before I do, two important areas that I will concentrate on in relation to where the trial judge went wrong was in his apparent treatment of the dividend issue, even though dividends was not a ground of complaint by the petitioners. They merely sought to reserve their position. And the very important point that Lady Arden has raised, which is in respect of the failure, for whatever reason it might be, to ask for information on the part of the petitioners. And whatever the reason may have been, it's a decision that they took consciously. It was a strategic decision. And in fact, it would be wrong to think that they only took that position or failed to ask for information since 2006. The simple position is that they never asked for information until, certainly not formally, until the beginning of 2014. If I could ask you just on that point, to make that point good, I may come back to it. If you'd look, please, at the letter that started the whole litigation off from Harney's, at page 1588, I hope. It's bundle C. It's the exhibits to Ronald's, if I can be forgiven for referring to them by their names. It's Ronald's Exhibits, tab 21. If you look at 1588, it's the letter from Harness on the 3rd of March 2014. This is the first time that matters became formalised, and you can see that it indicates who they act for, and it refers to being put on notice as regards the provision of the memorandum and articles and so forth. But then you'll see the last paragraph on that page. Further, you failed to make any report of the company to the minority shareholders since 1994. As you're aware, as a director of the company, you owe the company common law duties to act without negligence, etc. Under section 120 of the Act, in exercising all your powers, and then a reference to section 121, and then over the page, in breach, you failed to give any report regarding the management of the company to the minority shareholders. You failed to convene a shareholder meeting since 94. You failed to issue any dividends since at least 1994, when a payment was made by a cashier order to the minority shareholders. The purpose of the payment is unclear. So not only did they not ask for information since 2006, they never asked for information. What prompted them to ask for information was not a concern as to mismanagement. What prompted them to ask for information was, as they themselves readily accepted, was a desire to see what the financial picture of the company might be, because they wanted to sell their shares. Their whole motivation, I don't criticise them, but their whole motivation in asking for information in 2014 was prompted from the short dinner that was held between Bertha and my client Lawrence, where it seems as though the possibility of a sale of Bertha's shares and a purchase by Lawrence was briefly discussed. And that came to nothing. And Bertha wrote an email a couple of months later. It's exhibited, I can take you to it if you wish to see, in January 2014, saying they hadn't spoken to each other for 15 years and that she would like some financial information. That led nowhere. And then we have the Harney's letter that was written, as I've just shown you. So the position was tolerated. It was only because they wanted to know about the financial position from the perspective of trying to negotiate, it would seem, a purchase or rather a sale of their shares. And the simple point is this: if the remedy had been correct Article 120 and provide them with the financial information that they'd asked for, they would have been put back into the very position which they would have been in at the time that they first asked for the information. And it is relevant in our submission that it's only by way of amendments that paragraph 12 comes in, when for the very first time allegations are made of the type that are set out in paragraph 12, but in circumstances where, again admitted by the petitioners, they knew about all of that relevant information for a considerable period of time before they raised the allegations. What is quite strange is that my client put in quite a bit of detail into his defence, and that seems to have prompted the amendment. But they had the information that they put into the amendments, at least on the significant issues, before they saw my client's defence. Again, I will develop this, but for example, a friend talks about the 18 Hong Kong dollars, the 18 million transaction, and transactions in relation to subsidiaries and 5 and 2 million and so forth. The 18 million goes back to the 1990s. And it's clear that the petitioners were aware of that transaction at the latest in 2005. There is no issue about it until their amended pleading. And what is significant, and I'll take you to the judgment, is that in our submission, no weight was attached by the trial judge to the fact that the petitioners had not asked for information since 1994, certainly since 2006, had tolerated that position, and had not raised any of the complaints that they sought to raise by way of their amendments. Because whilst the phrase little or no relevance was used in the judgment, that was in the context of the allegations of misconduct on the part of the petitioners in respect of their behaviour between 2004 and 2006, when in breach of various Hong Kong court orders, they made payments to themselves or allotted shares to themselves. That phrase, little or no relevance, does not appear to us to be referring to this issue, which is one of inactivity in relation to the various matters that I've just sought to describe. And as I'll show you in a moment or two, the treatment of the judge on the question of dividends is a matter of real concern in circumstances where the issue of dividends was not being raised as such as either a ground, certainly as a ground of unfair prejudice. This was not a case, for example, that one might be accustomed to seeing, where a ground of the allegation of unfair prejudice was specifically, you ought to have issued dividends and you failed to do so, or you've not issued dividends, but you have made excessive payments to yourself as the majority shareholder by way of remuneration, and we've lost out in that way. That was not the allegation. What was said, of course, specifically, and this was not amended. If I could take you to the statement of claim, please. The amended statement of claim, indeed, which is tab 37. And it starts at page 2040. My friend's already taken to paragraph 12, which I'll come to in due course. But if you look, please, at paragraph 14 of the amended statement of claim, it's under the heading possible mismanagement. And it says, as set out in paragraph 6, the claimants have not received any dividend payment from the first defendant since May 2006. By reason of the matters pleaded at 7 to 13, the claimants also have reasons to believe that since the second defendant became the sole director, the affairs of the first defendant have been conducted or likely to be conducted in a manner unfairly prejudicial, etc. The claimants reserve the right to provide further particulars to substantiate this claim and to amend on being provided with information. So that's what it says about dividends. Can I also make the point, again, to return to in a second, at paragraph 6, which is referred to at 14. It is acknowledged that the relationship between the claimants and the second defendant broke down in 1994. This is not, in our submission, a breach of trust and confidence case in, if I may be allowed to call it, the traditional sense in unfair prejudice petitions. This is a relationship which, regrettably, no doubt for all concerned, has been broken since 1994, 20 years plus by the time this piece of litigation was started by the petitioners. It is not the act of changing the articles in 2014 or the refusal to comply with the request from Harness to provide information that broke this relationship. The relationship had been broken for 20 years before any of that took place. I'll come back to these points because it's significant to see that the judge, again with respect, completely, if I may say, overlooked or certainly made no reference to those factors when considering what was the appropriate remedy. The other factors which don't appear to surface as significantly, we say, as they should have done in that part of the judgment dealing with the remedies, are the facts which earlier in his judgment the judge had acknowledged were common, namely, this was not a quasi-partnership. There was no question of the petitioners ever having been involved or indeed interested in the management of this company. They had never participated since its formation in the beginning of the 1990s, or were expected to. The only time that they became involved in any managerial capacity was in 2004 to 2006. That, of course, arose, as is set out in the papers, because they had commenced litigation in Hong Kong, challenging the claim by my client that he held 10,000 shares in the company. They disputed that and made accusations of fraud and forgery in respect of the relevant documentation. They succeeded at the first instance hearing. That led to the appointment of receivers, and it also led to their active involvement in management. They ultimately failed on appeal in relation to their allegations, which restored matters back to where they had originally been. For that short period of time, the petitioners have not been involved in this company at all, nor were ever expected to be involved in the company. So there is no issue of joint management, which is highly significant, we respectfully submit, in terms of the appropriate remedy. Clean breaks are often considered appropriate, or always nearly considered appropriate, in circumstances where to not make a clean break runs the risk of perpetuating inevitable problems which are going to continue in terms of joint management, or will perpetuate existing disputes. And when we look at Grace, I'll seek to develop this, that when it talks about usual orders or most cases, that no doubt is correct in the context of quasi-partnership. Furthermore, another obvious factor, which again the judge earlier in his judgment accepted and noted, is that this is not a case of, to use the phrase which I know has been reeled back by Lord Hoffman, but the convenience as a label of legitimate expectations. This is not a case of the petitioners coming along and saying that they had any expectations over and above effectively Article 20, 120, and the information that they say that they were entitled to. But if the remedy had been restore 120 and give them the information, then they were exactly back to that position. So the petitioners did not complain about being excluded from management. They asserted no expectation to ever be in management. And significantly, they did not make a case of unfair prejudice based on non-payment of dividends. The highly significant point as well is that when the petitioners very late in the day indicated that they wished to amend their statement of claim, there was obviously a concern, because it was very close to the trial date, that the trial should not be adjourned if it could be avoided. What was pressed and what was secured by way of agreement was that the petitioners, in return for the agreement on the part of the defendant to allow the amendments, would agree that they would not seek to change their evidence in chief in order to substantiate any of the points raised by way of amendment. But as I've already indicated, this is not a case in any event where non-payment of dividends or even non-consideration of non-payment of dividends was advanced. What was said was, we've got concerns and we reserve our position. And I'll develop that a bit further in due course. What we do know, what is clear, is that this is a case where, as I've already sought to stress, the relationship had been broken since at least the early 1990s. And indeed, if one looks through the documentation, one can see that there were fundamental problems with the relationship between these siblings going back to the 1970s. It's a regrettable fact that the petitioners, other siblings who are not part of this litigation, and the defendant have had a bad, broken relationship throughout most of their, if not all of their adult lives. I say the 1970s because you'll have picked up from the judgment that in the 1970s, the father of all those concerned had gifted shares in another company to them. But as a consequence of fallout, he demanded that they all return those shares back to him. So this is regrettably a family, and therefore shareholders in a company whose relationships have been broken, but not as a consequence of anything that was put before the court in relation to the articles and payments. I've touched briefly in relation to the amendments, and again, I will develop this fully as it may be felt I need to do so. But in relation to, going back, if I may, for a moment, to the amended statement of claim, just to pick up briefly, but just to jump around a little on paragraph 12, you have these allegations that are being met, that are addressed here. 12A talks about varying descriptions of some transactions involving the petitioners. Again, I can give you the reference in due course, but just to put that in context, it seems that at some stage, the defendant had described a transaction as a gift to the petitioners and another as a loan to the petitioners. But that's as far as that went. Paragraph B is the same, just varying descriptions that have been given in respect to some transactions. 12C is something that goes back to the 1990s as the transaction itself, but the petitioners were aware of this in 2005 in the context of the Hong Kong litigation. And we can say that with confidence because there is correspondence, again, I could give you the references in due course if you require them, that shows that the petitioners, in particular Ronald, was pressing repeatedly the receiver to bring proceedings against my client in respect of these allegations of payments. So those, again, very old allegations in relation to this. D, it's important to see how it's put in the pleading. The second defendant's purchase of shares in the first defendant from 3 of the siblings for less than the value he ascribed to them, and without providing the financial records of the Ming Group to the vendors. Of course, the vendors themselves, being the other siblings, not a party to this litigation, gave no evidence in this litigation, and there is no evidence of any complaint or concerns expressed on behalf of those siblings, and there is no investigation at trial into any of the detail relating to those transactions. E is the second defendant's desire to buy the shares of the claimants at a price set without providing the claimants with financial information. Well, again, by definition, that is easily remedied. And that remedy would be correct Article 120 and give them the information. F is recognition of the desirability of the association being brought to an end. That would hardly seem to be a cause for real complaint. G is part of C again, if I can put it that way. It's a complaint about payments being made. Again, those go back many, many years, and again are matters which were known to the petitioners in 2005 at the very latest. Indeed, you can see from paragraph G, the financial records of the Ming Group show the second defendant used the funds of the two subsidiaries amounting to $8 million to meet his legal fees, as referred to in a letter to the first claimant from Mr. Robinson on the 14th of January 2005. So the petitioners themselves indicate and express there that they've known about that for 10 years by the time of the trial. And then H, the findings of fact in the High Court judgment in Hong Kong, well, that was rather difficult to understand what side that would be, but obviously, again, that was 2004. So obviously, again, they knew what those findings were back in 2004 when those findings were expressed. Nothing about the antiquity of those allegations, the knowledge of the petitioners about those matters of complaint, nor the fact that they made no complaints until days or so before the trial was due to commence by way of amendment, was referenced by the trial judge, or it seemed to have been regarded as having any relevance or consideration whatsoever. But we say that clearly is highly relevant to the remedy that's to be granted. Because if somebody has sat back and done nothing for maybe 20 years, or at the very least 10, and then at a dinner at the end of 2013 said, I might be interested in selling, could I please have some information? We were told no. And then my client acted in the manner that he did, which has been corrected in 2014. The question must arise in our respectful submission, well, why should we be granting you the order for a buyout now when you've not complained in all of those years, and when your actual direct point of complaint, namely the article change and the refusal to give you information, can be remedied, and that will put you into the position that you say you wanted to be in and why you asked for the information in the first place. What the judge in our submission appears to have done, and I'll come on to Grace now in a sec, is use comments from the Grace Biagioli case as almost a green light to say he can move on to make any order that he might wish. And again, when one reads in our submission the judgment, it seems as though he has, with respect, forgotten or overlooked the observations in O'Neill and Phillips, which is that a mere breakdown in trust and confidence alone is not sufficient. And what he appears to be motivated by is a desire to assist the petitioners, who are minority shareholders, to unlock and liquidate their interest in the company, but in circumstances which, in our respectful submission, are unprincipled and completely lacking in any justification based on any application of any rational principles. It seems rather a desire to assist them in some way to unlock the value of their shares. And I'll take you to his judgment, where we respectfully say that is all apparent when you come to these passages. If I could take you, please, I'm conscious of time. I'm just if I take you to the Grace Authority, and I'm conscious my friend has already done this, so I can probably move this quite quickly. It's, I think, in tab, I've got mine in hard copy I'm working for, I'm afraid, but I think it's tab 63 of the electronic copy. The head note you've already been referred to. It's the facts of the case, of what that's worth are. Sorry, my lord.
Mr. Chasey, I'm afraid I think we're all
using, certainly I'm using, electronic bundles which don't have tabs. So if you could give us page numbers, that would be very helpful.
It's 2490.
2490, thank you. And my lord, you've been taken to the head note already, and it's clear and stark that the facts, for what it's worth, the facts of the Grace case are a considerable distance from the facts with which we're concerned with on this appeal. And at paragraph 8 of the judgment, the court there addresses the second ground of appeal relating to the question of the remedy, and it's perhaps just worth me stressing what's said there. After the beginning of the second sentence, although the judge found that the non-payment of the dividend did amount to unfair prejudice, it's contended that he took far too narrow a view of the underlying reasons for it and of the seriousness of what was in fact done. As in the case of his removal as a director, Mr. Grace contends that the non-payment of the dividend was not an isolated incident, but was part of a wider decision taken by the respondents to exclude him from participating or from deriving any benefit from the company as a shareholder. The non-payment of the dividend not only contravened the decision taken at the AGM in December, it also represented, he says, a repudiation of the basic agreements made between him and the respondents prior to the formation of the English company. He contends the non-payment of the dividend and its distribution amongst the three other shareholders is symptomatic of a complete breakdown in relations between them, and indicates that the respondents will never willingly allow him to obtain any further benefit from his shareholding. It seems, if I may respectfully say, it's not always easy to distill the precise reasoning in the judgment at first instance, but it seems likely, if I can put it that way at least, from what I'm about to show you in the judgment, that registered, as it were, with the judge as significant observations. But the paragraph that he, I would respectfully say, seems to have taken as a green light is, I think, paragraph 75. This is the paragraph that he quotes. And at paragraph 75, this is perhaps worthy of stressing. It says, in most cases, the usual order will be to make the one requiring the respondents to buy out the petitioning shareholder at a price to be fixed by the court. This is normally the most appropriate order to deal with intra-company disputes involving small private companies. This is relief which Mr. Grace says the judge should have granted, and which he seeks on this appeal. The reasons for making such are in most cases obvious. It will free the petitioner from the company and enable him to extract his share of the value of its business and assets in return for foregoing future right to dividends. The company and its business will be preserved for the benefit of the respondent shareholders, free from his claims, and possibility of future difficulties between shareholders will be removed. In cases of serious prejudice and conflict between shareholders, it's unlikely any regime or safeguards which the court can impose will be as effective to preserve the peace and to safeguard the rights of the minority. Although, as Lord Hoffman emphasised, there's no room within the jurisdiction for the equivalent of no-fault divorce. Nothing less than a clean break is likely, in most cases of proven fault, to satisfy the objectives of the court's powers to intervene. If I might respectfully say, that paragraph expresses some of the principles in very broad terms, and it would be wrong if the judge, as he may have thought, treats almost that reference to in most cases that there should be a compulsory buyout as almost a default position in relation to unfair prejudice claims. Our respectful submission is that, of course, the remedy should, so far as it can be, should be bespoke. It should be proportionate to the matters, and simply to refer, as it did also at 73, to saying take all circumstances into account, cannot mean, in our submission, that once there is a finding of unfair prejudice at any level in respect of any complaint, it opens the gates entirely and almost forces the respondent through the gate to say it must be a compulsory buyout. I'm conscious that this authority isn't, I haven't put it before the court, but it's just a passage, in fact, from a case of Lord Briggs at first instance called Sikorsky. I just, if I may mention it, just to paraphrase the points that my lord made there, because Sikorsky did involve a case which was not a compulsory buyout. It involved two brothers who'd fallen out in relation to making payments from rental income of a company. And what was sought was an order that the company should be repaid monies which had not been properly allocated. And it was raised late in the day that an order perhaps for a compulsory buyout would be appropriate. And my Lord Briggs, in that case, made the observation that whilst compulsory buyouts might be common, of course, it was also appropriate to look and see if you could tailor the remedy to match the issues in the case, and that in circumstances where you were not going to perpetuate problems for future joint management, which you're not going to here, and you're not going to perpetuate existing disputes, then you can make an order that is less than what one might call the fairly draconian one, but for many respondents, of a compulsory buyout. And what I would say is that 75 has to be taken quite carefully, and the judge below perhaps didn't do this, in terms of the reference to most cases. If the remedy in most cases is a compulsory buyout, it might well be, because most cases that come before the court of unfair prejudice are what one might call the standard quasi-partnership, joint management, exclusion from management. Those are the standard types of cases. And so to that extent, the reference to most cases having that remedy might be perhaps appropriate, but otherwise it's difficult, my lord.
I'm sorry, Mr. Chase, is Sikorsky in the bundle?
No, it's not. I'm sorry, it's not. And I apologise for that. It only is something that I observed very late this morning. I recall that my lord had been involved in that case of Sikorsky when sitting at first instance. I can do what I can to correct that, but I was merely paraphrasing a passage which comes from my lord's judgment, which on reflection did seem to be quite a neat encapsulation of, if I may say, some of the points I think I made.
Is it a reported case?
I certainly found it easily enough on Westlaw, but I can check that from the law.
Thank you.
I'm conscious of the time.
Is that a good moment to break for the lunch adjournment? Thank you very much indeed. We'll resume at 2 o'clock then. Thank you.
Thank you.